Mr. Chair, we haven't started, but we're making a start right now. We've formed a quorum. I think the clerk has already carried out a head count. We've formed a quorum. So I'll call the meeting to order. Now, this is the 21st meeting of the Stamp Duty Amendment Bill 2012 Bills Committee. In accordance with the advice of the clerk, I need to declare my interest. I'm an accountant, and then my firm has been providing a lot of advice on taxation for many clients, including all types of taxation, including stamp duty. I myself do not take part personally in the work. Chen Ken-nam, I repeat the declarations already made. Kenneth Leung, I own properties. I also provide stamp duty advisory service. Or do you collect the duty? Mr. Wong Tin Kwong, Madam Chair, I repeat the declarations made in the past. Mr. Chair, I also repeat the declarations already made. Ronnie Tong. Who else would like to make declarations? You only need to declare your interest if you want to speak according to the rules of procedures. Members, I'm grateful to you. I understand that there is a clash of meetings, many meetings. We are grateful to the administration for dovetailing the meeting schedule of the Bills Committee. Well, tabled before you is a copy of the paper from the administration, and the paper has been submitted in response to members' requests. At the last meeting, the committee already completed the cross-by-cross scrutiny of the bill. Now, the administration has come up with the latest version of the government's CSAs. I will invite the administration to walk us through paper CB bracket 1698/13 to 14 bracket 03. I will go through them one by one, and then the legal advisor will check if he has got any questions. Mr. Chair. Are we going to skip CB bracket 1698/13 to 14 bracket 02? Certainly we'll come to that, but I suggest we deal with the CSAs first. Madam Chair, I've asked for a copy of the minutes. That is, I would like to know about the points made by the Secretary in relation to the case of minors. Yes, we are aware of your request. I think we'll wait for the admin to tidy up the paper, and then we'll submit it to you, Mr. Chair, after the meeting. Ms. Wong. Madam Chair, I would like to sort of tender our apologies. We've only got a few days in between the meeting last time on Monday as well as today's meeting. So it was quite late in the evening last night that we were able to finalize the CSAs from the government. The paper has been tabled for your reference. Allow me to say this. This is already the full set of government CSAs. And it covers the following. First of all, provisions already examined by members during your cross-by-cross scrutiny. And then we have some amendments or revisions to the CSAs, some amendments to the original provisions in the light of the comments of deputations, legal advisor, as well as our own law draftsman. So the annex to the paper is already the complete version, covering both the latest revisions as well as the earlier proposals. They have been set out in different colors to facilitate your reading. As to the details, you'll find the explanation in the paper proper. There are three major types of amendments. First of all, the administration has already decided to take over the proposed CSA from Mrs. Regina Yip. That is, we're going to remove the BSD exemption for the acquisitions of residential properties made by minors through the trustees and guardians. It is being marked in yellow. Another point is that, in the light of the further advice from the Law Society, for instruments not yet duly stamped, and for them to be received in evidence, we would like to make further adjustments to the provisions, and the provisions are marked in green. And then the third major category are technical amendments, so as to clarify the drafting of the provisions. We have already taken on board the views of the legal advisor of the Bills Committee. So you'll find them being marked in grey in the annex. First of all, if I may talk about the proposed CSA from Mrs. Regina Yip, please refer to those parts marked in yellow. We'd like to amend clauses 9 and 12. Why don't we use the marked up copy prepared by your secretariat? Two sets of marked up copies were prepared, one thicker, the other thinner. Please go back to paper, rather the page 27. CB bracket 114, 13 to 14. You mean the one which is printed on the A4 paper? CB bracket 1454. Let her finish first. Can I ask a question about the papers? Is it the one not given a serial number? Is that the full set of CSAs? Do we have a marked up copy? No, we haven't got time to do it. You have to read it together with our marked up copy. So please use the marked up copy we used during the cross scrutiny. There are just too many papers. First of all, let us clarify this point. The Secretariat has prepared two sets of marked up copies. CB bracket 1454/12 to 13 bracket 02 on A4 paper, and then the other one on A3 paper. And the paper number is CB bracket 115/13 to 14 bracket 02. My understanding is that we've only got these two sets of CSAs. Is that right? It's wrong. Yes, I think we have got two. I think just now Agnes was referring to the one printed on A4 paper. We used this one during the cross scrutiny, so I think it's easy to identify the paper. Is that fine? All right. Which page? 0027. Both are printed on large-sized paper. No. We have got the bilingual versions for both papers, one on A3 paper, one on A4 paper. Which page? Page 0027. We're still about the need to amend the provisions in the light of accepting Mrs. Regina Yip's proposal. Clause 9. Would like to amend 29CB, bracket 8 bracket B and bracket 9 bracket B. So we are going to delete either a manner or. So if he is a person who is mentally incapacitated. Mr. Wong, 4 minutes. Well, in relation to the question about the case of Mana, I have some reservation. I think the Bills Committee has also got reservation, but then Mrs. Yip is now moving a CSA. Now, I want to ask this question. What is the justification? Well, if we are to endorse the amendment, now you are saying that the one concerning a person who is a mentally incapacitated person, then it will be retained. Now the government is to take over Regina Yip's proposal. I want to know whether it will be subject to judicial review, saying that it breaches the basic law. Now, if you go along the same logic, now if it is ruled that that person, if it is thought that minors don't need their own housing, I think the same can apply to mentally incapacitated persons. Now, if a mentally incapacitated person requires a trustee or guardian to take care of the housing needs and therefore buy a property on his behalf, then if that logic stands, what about the case of minor? Unless you can make a distinction between the two sorts of cases, otherwise, I would say that it will be unreasonable to withdraw the exemption. That's why what I'm saying is that perhaps you need to delete the reference to mentally incapacitated person. Otherwise, your justification is not sound. Ms. Wong, well, let me go back to this point.
We have explained why we accept Ms. Virginia Yip's proposed CSA. For the minors, we remove the exemption, and the major consideration is this. Relatively speaking, we accept the members' proposals in this committee. In terms of their financial capability and their ability to take care of themselves, the minors need to rely on their parents or their guardians. So the need for buying their own houses is relatively small. Members have repeatedly raised at this committee that minors, especially the type 2 children, might be used by other people, and that will be a loophole of this amendment bill, or the bias-stamped BSD. So that might be, we agree that this may be a loophole, and there is a need to tighten up the provision. So for Article 25, we have to look at 3 factors: legitimate aim, and whether our policies can achieve that legitimate aim, and then the proportionality of that measures taken to achieve the legitimate aim. So after taking into consideration all these factors, we have agreed to Ms. Virginia Yip's CSA, and I think all the factors are there. Now, as for mentally incapacitated persons, compared to the minors, they may have the need for home ownership, so we don't want to rule that out. And in the mental health ordinance, there is a stringent requirement on guardians for mentally incapacitated persons. So the chances of abuse of the provision is relatively low. So that's why we agree to Ms. Virginia Yip's CSA to remove the exemption for minors. Is that laid out clearly in CB 162303 paper? That's in another paper, 1698-131402, and also in another paper, 1623-12-1304 paper. I found 3 grounds in 03 paper. Which paper is it? It's 162303. Because that lays out your justifications for accepting Virginia Yip's CSA. So can you list all the grounds? So you said that the arguments are not there in this 623 paper. well, actually, that paper lays out all the grounds, but then at the last meeting, you asked us to lay out the grounds again. I want to discuss with you how these grounds relate to people who are mentally incapacitated in terms of circumventing the tax payment and so on. I am afraid that I might have missed some points. I know that there are several grounds in 162303, so I would like to go through them one by one with you. In paragraph 4, you said that members are concerned about the issue, including Regina Yip and myself. But from a legal perspective, some members said that they are concerned about issue A. But then that doesn't mean that the government, say, is meeting with the requirement of the basic law. That's not necessarily related, these two issues. That should not be a good justification. Secondly, some members have suggested that the minors might live with their parents, and so there is not a need to give them the exemption. But this is questionable. I can also imagine that mentally incapacitated persons also have a place to live, unless he were missing in the streets. They are just like the minors. While they may live in residential homes for them, they don't have a need for home ownership either. So I don't get it. The same rationale applies. Now, if we take all these cases to the court, how can you resort to these grounds to delete the exemption for the minors and not for the mentally incapacitated persons? So I think this is a same dangerous situation when it comes to the legal argument. Mentally incapacitated persons don't have a home ownership need either. So I think the two groups of people are the same. I urge the government to think about this carefully. Once you've made the decision and that the case is taken to the court, then I'm afraid that the people may take issue with the provisions of the law. So I hope that the government can prudently think about this. I agree that that there should be a tightening of the exemption for minors. But then if you don't do it for one group and not the other, then it will be very dangerous. All right, Mr. James Toe has expressed his views clearly. Okay. Is 623 already lays out the ground? Apart from this, and if you look at the other paper, 698-1314-02, we also made the point about whether we are meeting with the requirement of Basic Law Article 5. So I think we have laid out the three grounds to look at the issue, and it's all a matter of proportionality or extent. We have explained that for the two groups, minors and the mentally incapacitated persons, the needs for home ownership are a little bit different. Of course, cases do vary, but relatively speaking, in most of the cases, a minor lives with the parents or his parents. So I think after carefully consider the members' views, we think that this is a point that can be taken on board. We have thought about it carefully. We've heard Mr. James Toe's views. I don't know what the other members' views are. In the meeting, members said that minors don't have an own home ownership needs, and then there may be a loophole. But for mentally incapacitated persons, the loophole may not be that big. So should we take a cutting across the board approach? I think we should take a balanced decision here. I hope that the administration should think about this carefully. I think I'm not sure whether you have listened to my view. I have talked about mentally incapacitated persons many times. Not many other members have spoken about this point. Well, in the past 2 years, there are more type 2 children here in Hong Kong. You may recall that in some mentally incapacitated persons living in residential care homes, it's difficult to track their records. Of course, these mentally incapacitated persons can recover, but the chances are low. And these mentally incapacitated persons, young people, may grow up and then, or rather the minors may ask that the houses be returned to them after they grow up if properties are purchased on them. But for the mentally incapacitated persons, the chances of that happening is low. Well, for mentally incapacitated persons, they may live in residential care homes and others may live with their family members. Do they have a home ownership needs? Their case is the same as the minors. They really don't have a high home ownership need. Okay, please be quick in raising your question. My view is this: you have to consider the quality of opinions and not the number of members raising a particular point. You have to make comparisons appropriately. There may be abuse related to purchase of properties by mentally incapacitated persons that has been raised in past meetings. And most members are rather concerned about abuse relating to minors. And the chances of that happening is high. I would like to add one point, and that's my question. For mentally incapacitated persons, if they are to be exempted from the BSD, what are the criteria and what are the procedures to avoid abuse of the exemption? Now, if there is this one mentally capacitated person, he or she must be an HKPR, and if he purchases a property through the guardian or trustee, when we look at the mental health ordinance, there are stringent requirements. There should be a doctor's certificate, and in that ordinance, at some occasions, they may have to appoint a guardian at the court, so that provides for some basic protection. Now, as for trustees, there should be a formal trustee agreement. So at the IRD, it will not casually accept a person as a mentally incapacitated person. Mr. James To mentioned whether these people are staying with their parents. Well, that's quite unknown because they are adults. Perhaps they have their own houses or own homes and they are asking someone to take care of them. But that's not the situation in the case of the minors. Minors usually live with their parents. So that's a little bit different. So that's why we try to draw a line here. Mr. To? The chances for seeking a judicial review, well, for any revisions in the provisions may invoke people seeking judicial review. And then the same goes for, say, the trustees of the mentally incapacitated persons. They may also seek a judicial review. Let me finish first. Well, I think it's good that Mr. To, you raised your concern to the administration, and it would be up to them to make preparations should any judicial reviews come along. Theoretically, of course, anything can be subject to judicial reviews, but now you are originally having two groups of people subject to exemption, and now you are reducing or cancelling the exemption for one group. Now, so the risk there is different from the case that when you are, say, taking away the exemption for both groups. So the judge's consideration may be different in such a scenario. Now, you have laid out the grounds for cancelling the exemption for the minors. And if the justifications are not good enough, and the risk will be higher for those if for groups where the exemption is not taken away. The Secretary General said that a mentally incapacitated person can live on his own. Well, same goes for minors. Say for an older minor, he or she can live on his own too. So you were proposing originally for these two groups to be exempted because you felt that they usually lived with their parents or guardians. So the chances for these two groups to be living on their own are the same. So the two groups may be living with their parents, and they may be living with in residential care homes. Say the minors may live in an orphans too. So I don't think the justifications are good. This is a matter of fact. So would you be actually putting yourself in a risk because of your CSA?
Which from your team can provide some legal advice? I appreciate the point made by Mr. James Cho. Well, the original intention of the bill isn't so much about whether the person is being taken care of or not. Initially speaking, we thought that for these two categories of persons, they would require others to help them to do the work. They need others to sign the documents before they can acquire a property, and then they will get the exemption. Now, we say that we are accepting Mrs. Regina Yip's CSA because, having heard members' views, if we are to withdraw the exemption for minors, we believe that we are still able to meet the various principles without jeopardizing the housing needs of the minors. In the majority of cases, minors are expected to stay with their parents or their guardians, and they are being taken care of. In most cases, in theory, a minor has a lower need to buy a property in terms of financial resources or other factors. So, against such a background of so many factors, we find it acceptable. Mr. James Cho, I think your point is loud and clear. They will assess the risk. So, can I check with the administration? Is this the final position? I have something new. Yes, please share with us. Now, your starting point was, when you first raised the proposals, you said that minors and mentally incapacitated persons must be Hong Kong PRs in the first place. Now you are withdrawing one of the exemptions. In other words, a minor who is a Hong Kong PR would say that he may also have a housing need. Or rather, it isn't a housing need, it's a matter of property ownership. Now please think carefully. Say, for example, with an estate, the father dies and he passes the money to his son, who is a minor. Now, it is said that the money cannot be spent. The money will be used in such a way that the income generated will be for the educational purpose of the minor. Now, the guardian is a non-Hong Kong PR. Now, the non-Hong Kong PR would say that, why don't I buy a property in the name of the minor and I'll be the trustee so as to get revenue in terms of rental. and then they can contribute towards the educational expenses. I think something reasonable for a trustee to think of such an arrangement. Now you're saying no, you can't do it. Property acquisition, a need for it. For someone who's mentally incapacitated, I think it is more than property ownership. Well, if you ask me, I hope the administration would give this consideration. I would rather take out the reference to mentally incapacitated as well. This is to prevent the provision being struck down. As the chair has said, I cannot convince you. Too bad. But I can also think of moving my own amendment. But then you are the government. First of all, you proposed 2 exemptions, and you're withdrawing one of them. I have to be clear about your justification. And then I want to give my comments for your consideration. I think it's very clear. Do you have anything else to add? I think Mr. James Cho has gone over his arguments many times. But of course, you may want to think of it from another perspective. I don't think I have anything to add at the moment. Please carry on. Just now, I've said that for 29 CB, bracket 8B, bracket 9, bracket B, we are deleting either a manner or. Please continue. If I may continue with those marked in yellow, covered by Mrs. Regina Yip's proposal. That's about clause 12. So please turn to page 0043 of the marked up copy. We are actually making the same revision. So for 29 dB bracket 9 bracket B and bracket 10 bracket B, the same few words, either a minor or, will be deleted. So the argument is the same, yes. So much for Mrs. Regina Yip's CSA. I think it is the same as those suggested by Mrs. Yip. We have checked it when we found it okay. Another one is about the admissibility of instruments not duly stamped with the BSD. At the previous meeting, I briefly mentioned this point. Section 15 of the Stamp Duty Ordinance provides that instruments not duly stamped are not admissible in certain proceedings, namely civil proceedings. Earlier on, in response to the concerns raised by the Law Society of Hong Kong and the Hong Kong Association of Banks, we have already submitted a CSA, and it was examined during the cross-by-cross scrutiny. Now, for the stamp duty, it would be the purchaser who would be paying the stamp duty if, in case the purchaser doesn't pay the duty, and as a result, the instrument cannot be produced as evidence by the vendor or somebody else, then it will be bad, and we don't think that they should be affected in this way. Originally, we have proposed a CSA. First of all, we say that the instrument must be produced by a person other than the buyer. And this is the most fundamental point. We've also said that perhaps 2 other conditions should also apply. First of all, the instrument has been registered at the land registry, and then the buyer has made a misrepresentation. Say, for example, he claims that he's a Hong Kong PR, but in fact he is not, or instead of acting on his own behalf, in fact he isn't. We went over the CSA with you, and then the Law Society told us that they have further thoughts. They were of the view that there would be difficulties in the enforcement. They've cited some examples. Say, for example, if the purchaser doesn't pay the stamp duty and the purchaser has left, then the instrument could not have been registered with the land registry. Then the innocent party would find it difficult to prove that the purchaser has made a misrepresentation. We talked to the Law Society again, and therefore we've come up with a further amendment. What we're saying now is that for the instrument, of course, it has to be produced by a person other than the purchaser. But the other conditions proposed earlier can be dispensed with. We believe that this is not contrary to our policy intention, because the purchaser doesn't pay the stamp duty, but then this shouldn't jeopardize the victim in relation to the production of the instrument for evidence sake in a court. So we'd like to remove some of the conditions. So please go to the A3 sized marked up copy. We have already proposed a CSA. Now we want to make further amendments. Please go to page 0001. So the one marked in green in our paper. Which page? Page 1. Members, have you got it? Yes, the first page of the marked up copy, CB bracket 115/13 to 14 bracket 02. We would like to amend section 15 1B as to what will be included instead. Please take a look of our paper. Despite anything in subsection 1. And then we are going to delete some of it, and then we will say them, despite anything in subsection 1, an instrument that is chargeable with buyer's stamp duty but is not stamped with that duty may be received in evidence in civil proceedings before a court if it meets the following requirements. And it can be admitted as evidence. Now we have A. In the case of a chargeable agreement for sale, it is produced in evidence by a person who is not the purchaser under the agreement. Or B. In the case of a conveyance on sale, it is produced in evidence by a person who is not the transferee under the conveyance. In other words, it must be the innocent party who is producing it. For the previously proposed additional conditions, they will be dispensed with. This is in response to the Law Society's discussion with us. Only with such a revision can this be implemented. What about the Law Society's position? We have talked to them. They don't dispute with it. James Toh, 2 questions. I try to compare the two. Let's not talk about the BSD. Now, for an instrument to be stamped, a contract or a assignment. Now, if it hasn't been adequately stamped and the form has been filled, and then the IRD thinks that it's outrageous, it is a case of gross undervaluation. It wasn't discovered in the first place. In theory, the IRD may go after you to get the stamp duty. Even if it has changed hands many times, I want to know whether the protection is still be available. Yes, I'll try to answer the question. What we are talking about here is that we want the instrument to be produced in court for the purpose of evidence. Let her finish first. Madam Chair, I'm also talking about production of the document in court for evidence sake. Let her answer your question first. Now, for the stamp duty, whether we are talking about the SSD or the ephorium duty, it is jointly and severally liable. In the case of BSD, only the buyer has to pay for it. That's not the same as the SSD or others. So we have the case, we have the innocent victim. Now, if the BSD hasn't been paid and so it is not duly stamped, then the innocent party, the victim, may still produce this in court as evidence. So we've made it very clear. It is all because the BSD hasn't been paid, and then an innocent party is jeopardized. So we want to confine it to the fact that the BSD hasn't been paid. Now, for the AV still duty, both parties are involved, and so we won't have the same problem. So I want to know whether you have the same, because we have the ad valorem stamp duty, the AVD. Why not? Now you are saying that the other party is innocent, but we may be talking about subsequent buyers since the property has changed hands many times. So I want to know whether the same protection, the same safeguard will be available. Yes, let me defer to the IRD. But I want to say that we are not about AVD, we are talking about BSD. Yes, I understand. How come that I don't understand? I asked this question. This is all because I've got a point here. I want to check whether it is a reasonable safeguard to be included. IRD? Deputy Commissioner? Now, if the instrument at the time of production has been duly stamped, then of course there won't be a problem of having to make up for the shortfall. Say, for example, at a later stage, if we need to pay up for the shortfall, like the AVD, then the position at law is that the person who submits the document has to make sure that the additional stamp duty has already been paid up, and then the instrument can be submitted in court.
Oh, it's exactly because of this. There is no special protection to the scenario mentioned by the IRD representative. Banks are used to accepting mortgage applications for that kind of scenario, and they have to bear the risk too. The banks have to bear the risks. Why is it that for AVD, the buyer has to pay, and then the subsequent buyers do not have to pay the stamp duty? Well, you have to explain why the additional risk is higher in this particular case. Secretary General? All we can say is that, as I've said before, we're now talking about BSD here. And I understand that Mr. James Toh wants to take a broader perspective. This proposal is made in response to the special request by a particular society, the Law Society, and this doesn't run against the policy intention, so that's why we think this is acceptable. Now, as for the cases of a AVD, well, it's not related to this case because we are focusing on the BSD this time. Well, so Mr. Toh, do you mean that you don't want to accept this proposal? I have another question, then you'll come to understand what I'm driving at. When I studied tax, when in school, documents which have not been stamped could not be produced in court. This is a golden rule, and this is your policy. Now, for AVD, there are so many transactions, and banks are taking the same risk, and the banks are getting used to it, and they have to bear the risk. Now, for SSD and BSD, you're saying there is extra risk created. Does it mean that the banks have to shoulder extra high risk? And this is your principle that documents not duly stamped cannot be produced in court. You should do everything by principle and not by convenience. Well, the government should not accede to a certain request of a society without taking heed of certain principles. AVD, the bill on the AVD has not, the scrutiny of that bill has not been finished, right? I'm not talking about that AVD bill. I'm talking about additional protection here. And the court can ask you to pay the BSD before any documents are produced in court. As I've pointed out the difference. In the BSD, it's just the buyer who has to pay the BSD. But for other transactions, all parties have to pay the SD. So in the BSD, there is this the existence of an innocent party. And we are trying to focus on the BSD cases here. The AVD has been implemented for so many years. And the banks don't find that there are so many risks which cannot be tolerated. Well, I understand your viewpoint. My second question is, you added in 1B, do you have an innocent third party, clean hand, or equitable not colluding and so on? Would these kind of wordings be included? Do these wordings have to be added? Well, if we don't have such wordings, people may be trying to circumvent the provision deliberately, say for those who are trying to avoid paying the BSD by colluding with another party and so on. Well, this is a new viewpoint expressed by Mr. Zhou. I think we have already discussed these provisions before. That's number one. And I don't know how to define innocent parties. So for the whole provision is really allowing for some certain documents to be presented to the court as evidence, the admissibility of the evidence. I think that should not be a decision made by the IRD, but rather the court. So it would not be proper for the IRD to decide on who is innocent and who is colluding and so on. Do you have anything to add, IRD? Let's take a look at BSD. Only the buyer has to pay the stamp duty, but for AVD and SSD, both the buyers and the vendors have to pay the stamp duty. Now, as for the exemption of BSD, it hinges on whether the buyers claim that they are HKPR and they are acting on his or her own behalf. And that's very different from the SSD and the AVD scenarios. All right, last chance for you, Mr. Zhou, to express your view. I'm not trying to convince the government, but I would rather to dispute their proposals. Well, the secretary said that it's all right for the documents to be omitted. Why we think that it's not appropriate originally because people have not paid the BSD. And that was meant to be a sanction for people not paying the BSD. But then you are saying that it's now the third party. Well, I'm saying that the third party may be innocent and may not be innocent. Well, the Secretary General is not from the legal profession. And it's natural that she doesn't find the wordings about innocent and equitable and so on not very necessary. So, well, in so many pieces of legislation, there are these kind of wordings. Now, in your paper, you said that the innocent third party is already implied. I thought that you are going to include expressly the wordings in the drafting. Well, it's just one phrase, innocent party, and then you can rule out all those parties who are deliberately flouting the law or who are colluding with other parties. That can protect your tax revenue. And using your own words, it matches your policy or legislation intention. Anything to add from you, Secretary General? Well, we will study later on whether we can take on board your view. Perhaps you can discuss with the law draftsman on the wordings, because Mr. Toh mentioned about this ground of yours about the request from a law society. All right, on 1B, small bracket B, in the case of a conveyancing on sale, it is produced in evidence by a person. You can just add in an innocent person there. Well, that's what I meant. All right, Mr. Toh is very specific in his proposal. So administration, please try to take it back and understand what can be done. Well, let's move on. The last parts are the parts marked in gray. They are all technical in nature, and including those suggested by the legal advisor of the Bills Committee. We try to make the provisions clearer. Now let's take a look at the gray parts. Shall we go through them one by one? Yes. In clause 4, bracket 3, if you look at the markup copy, that is the A4 size copy, is page 0002, i.e. that is page 2. We try to make the provision clearer. And section 4, bracket 3A, bracket B, and that is to say that the 各人均可被起訴 will substitute it by 有關法律程序可針對各人提出. This is really a clear way of rendition of the provision. The second part, grey part, is clause 5.1. In markup copy, as A4 size, is page 5. That is also made in response to the legal advisor's request to define clearer the mentally incapacitated persons. And now it is written is mentally incapacitated person means a person who is mentally disordered or mentally handicapped within the meaning of the Mental Health Ordinance, CAP 136. So we would like to add in one phrase, and is because of his or her mental state incapable of managing and administering his or her property and affairs after CAP 136. That was made in response to the legal advisor. That was also our original intention in the amendment bill. Please move ahead. And clause 8 in the marked up copy, A4 size, is page 19. It really is the change in the rendition of the clauses. In section 29CA, bracket 2, and it was as originally set with special stamp duty under head 11B in the first schedule if the residential property consent is disposed of within a period of 24 months. So we repealed 24 months, and then in section 29CA3, we also substitute a specified period with a 24-month period. Mr. Toh, if the technical amendments don't go against the legislative intent, please state so. Please, we might not be as well versed with the details as the legal advisor. All right, page 3, clause 9. If you look at the marked up copy, it's page 29 of the A4 size markup copy. And that is also has to do with the making the wordings clearer. In 29.9C1B, Originally, it said the person or persons to whom the residential property is to be transferred is or deemed to be the purchaser or purchases under the agreement. We now substitute it as and the person or persons from whom the residential property is to be transferred is or are deemed to be the vendor or vendors under the agreement. After the agreement, we want to make the drafting clearer. All right, please continue. And on the same page, 29cc2b, similar wordings here. Is paid by whom the person or persons by whom the consideration is paid or given or to be paid or given is deemed to be the purchaser. We suggest adding in the sentence and the person or persons to whom the consideration is paid or given or to be paid or given is or are deemed to be the vendor or vendors under the agreement after the agreement. That's also on page 29, is that right? Correct. And that is for 29cc bracket 2 bracket B, the same page. There is another amendment similar to the wordings just now, and that is subclauses 1 and 2, page 35 in the marked up copy. Well, similar wordings as before, as just now. In section 29DA bracket 2, it says that a conveyance on sale is chargeable with stamp duty under head 1A in the first scheduled. We delete a specified of 24 months, or we delete relevance specified period, and substitute specify in the first column of that head, and clause 12 in paper 5. In the marked up copy is page 46. We also want to make the wordings clearer in the proposed section 29DC bracket 2B. It says now that the person or persons by whom the consideration is paid or given is deemed to be the transferee. And we propose adding, and the person or persons to whom the consideration is paid or given is or are deemed to be the transferor or transferors under the conveyancing after the conveyance.
Please continue. Same page, 46. So we want to add word after that. That is, the persons to whom the consideration is paid or given or is are to be deemed. We want to say that that person should be regarded as the transferor. Yes, please continue. Clause 12. You need to go back to the A3 sized marked up copy, page 17. (29DD) bracket 1 bracket C, small Roman 1A. Yes, please continue. The applicant alone or jointly with the associated body corporate has A. demolished or caused to be demolished any building existing on the lot or the lots of the new lot. We have said any building. Now the draftsmen are saying that we need to make it clear, to make it say demolished or caused to be demolished all buildings, if any, within parentheses, existing on the lot. Okay, please continue. The last one, marked in gray. Mr. James Cho. I welcome this amendment because the original CSA may give rise to a loophole. Because as long as someone puts up anything, then it will be fine. Now you are making it better. Yes, you have made a point, and they have made a reply. The last one, the last technical amendment, clause 16, page 58 of the A4 sized marked up copy. The legal advisor is of the view that as it stands, it may not be that good, and so we would like to fine-tune it. 63A. The FS may, by notice published in the Gazette, amend a percentage specified in the second column of Head 1, 1AA, 1AA-B, 1B, or 1C in the first schedule. Now, I would like to read it out. The FS may, by notice published in the Gazette, amend a percentage specified in the second column of Head 1, 1AA, 1AA-B, 1B, or 1C in the first schedule. It is a matter of negative vetting. If we want to change the percentage, we would like to specify the sort of timing of acquisition of the property. So we want to make it clear. That is, we are only amending the percentage. Mr. James Toh, it was raised by the legal advisor. Can I confirm with the legal advisor whether it has already resolved the problem in relation to the sequence, whether the powers are adequate? Legal advisor. Madam Chair, yes, I confirm that this provision has addressed the concern that I have raised. All right, administration are finished. The rest have already been taken up in previous sessions. Legal advisor, can you confirm that the technical amendments proposed are in order after you've examined them, and they are not contrary to the original provisions? You can, of course, alert us later if you identify them later on. We have asked the legal advisor to check the English version as well. Have you got anything to say? Madam Chair, I've already told you what I have discovered. I haven't got anything else to say at this stage. When Ms. Wong examined the CSAs with us, we still have some drafting concerns. We are still at the stage of liaising with the administration. We can report back to you later on. Well, earlier on, a lot of CSAs have been proposed by members. Some of them have been accepted. And Mr. James Toh has also raised a point about the negative vetting. Ms. Wong, please confirm whether you've got anything else to propose, because probably today we have to wind up our discussion. Yes, I confirm that this is already the final version of the government's CSAs. Madam Chair. Can I not go back to the point about building? Page 5, right? Yes, indeed. 29 DD. I've got the scenario in mind. I don't know. I cannot recall whether I have already told you or not. Say, for example, we have got a 3-story building on an unrestricted lease. The plot ratio and the planning allows for a taller or larger development. This 3-story building has been purchased. In overseas countries, they don't have a lot of this sort of examples. In Wan Chai on the URA site, we have seen this. It is a 3-story building. They are supposed to be able to put up 30-story building. They could very well have put down the 3-story building and put up a new one, up to the maximum height allowed. There is this possibility. They don't put down the 3-story building. But then this may not be a heritage, though it's popular among the citizens. It hasn't become a gazetted building. He may not want to put it down, and then he would like to put 30 stories on top, like piggyback, carrying a baby on the back. In this way, I want to know whether you would agree with me that in this case you can't get the refund earlier. Would it be permitted or not? Ms. Wang, well, in simple terms, in this case, the conditions are not met. Now, the conditions, the requirements are you have to prove that you want to have a redevelopment. Therefore, if there are buildings on the lot, in theory, you have to demolish them unless there are other provisions. Say, for example, it has been graded as a historic building. Then you mustn't pull down things that you are not supposed to do so. Otherwise, everything else has to go. Therefore, for Mr. James To's example, I don't think it meets the requirements of redevelopment resulting in the refund. All right, I note the technical analysis, but what about the policy perspective? If they can maximize the land potential, there's the plot ratio, and it is a case of additional development. But then for the 30 stories behind the original block, it is in fact the concept of redevelopment, though there hasn't been any demolition. So in terms of the policies, I think this is in line with what you would like to promote and what you don't want to jeopardize. That is, you don't want the stamp duty to prevent redevelopment being carried out. Do you understand my point? So, in theory, I think you are supposed to look at this as well. I have to raise this point. This is because we have got buildings which aren't up to the level of heritage or monuments. But then there is a lot of collective memory. They may be special shopping streets. Citizens don't want it to be put down. The developer may agree, but then as a result of this BSD, the refund can only be obtained a long time away, and it's not a small sum, 15%. So I'm afraid this may become a negative factor for consideration, and then we cannot meet the public aspiration to preserve buildings which aren't yet historic buildings. And at the same time, we don't want to discourage this sort of additional development. Ms. Wang, I appreciate the point, but then if it is not a building which cannot be put down as a result of the provision, then anybody can come forward and say that I like the building so much that you mustn't put it down. Then it's difficult to execute, and it's difficult to draft this idea into the law, and it's not objective. As long as somebody somehow has said that he doesn't want it to be put down, then it appears to me that the relaxation is excessive and our policy objective cannot be achieved. For the point made by Mr. To, of course, perhaps in principle it is right, but as to how many cases there are in reality, no one can tell. Now, in fact, for redevelopments, we are already very relaxed. Should we be very, very relaxed so that there isn't even an objective criterion? So long as someone has said that it shouldn't be put down, then we allow it, and then it would be too excessive as a relaxation. Well, as you know, Madam Chair, that I try to think about both sides of the argument. No. maybe someone can make savings in BSDs by acquiring a small property, break it up into 10 different ownerships. I think the administration has got the resources, since I have already raised it, but of course I'm not too sure whether I've already raised it or not. But I think you need to consider it. If it is matching your policy objective and it can be rendered into legal provisions, then please go ahead. If you can't, then of course don't allow them to have a loophole. It's a 3-story building, and then they can just add 1 story, and then they have a chance to speculate. I think in reality, we are getting more and more such cases. This is all because of the changes in our values of the society. It may not be heritage class buildings. The developer may be criticized severely for demolishing it. Mr. James Tu, thanks for your idea. I hope the administration will consider it. We come to the last paper. The admin's response to the issues raised at the last meeting. Please take a look of paper CB bracket 1 698/13 to 14 bracket 02. This is about the adoption of Virginia Yip's CSA and the latest CFA's ruling.
Thank you, Madam Chair. We have already explained why we accept Ms. Virginia Yip's CSAs. I'm not going to repeat here. Now, as for Basic Article 25 and the CFA's judgment, well, in the past Wednesday, the Secretary has made a reply to an oral question. She has already made it clear. The CFA's judgment is very clear, and it was just specific to the CSA scheme. The court clearly stated that the judgment cannot be extrapolated for general application across the spectrum of all public services. So, for any policy objective or measure, one has to take into account the objectives, justification, other key factors to decide whether they are reasonable, rational, and constitutional. For Article 25 of the Basic Law, we said repeatedly at this committee about the 3 factors. While for the Basic Law, Article 25, that all people would be treated equally before the law, it is not exact equality. The consideration should be whether there is the difference in treatment pursues a legitimate aim, is rationally connected to the legitimate aim, and is no more than is necessary to accomplish that aim. We have said repeatedly that when we launched the BSD and also Ms. Virginia Yip's CSA, we think that these considerations have been met. And we have not done anything more than is necessary to accomplish our aims. I think we have discussed this many times. I would allow Mr. Shek to speak, but please don't make a lot of repetition. So, Madam Chair, why are you trying to restrict my speaking time? Why are you exercising that kind of right? I think you are targeting me, Madam Chair. Well, I'm not targeting you. Well, the members of the public know very well that every time I give you a chance to speak, well, why are you restricting my opportunity to speak? Now, I hope that you can retract your remarks just now. I have the responsibility to remind members about their speaking time. Well, Madam Chair, I have asked for this paper. Well, let me finish. We talk about Article 25 of the Basic Law. It should, the answer is too simple. It's in 2 pages. Mr. To talked about minors in the amendment bill, and I think a problem arises there exactly because of what Mr. To said. the explanation given in paragraphs 5 and 6 are problematic. Well, there is a very high chance that I will seek a JR. I've asked for this paper, and Madam Chair, it doesn't matter whether you are EXCO member or which political party you belong to, but we're talking about the right bestowed upon the people of Hong Kong by Article 25 and Article 105 of the Basic Law. And these amendment bills should not harm the right of the public provided for in the Basic Law. Please don't restrict my speaking time. I don't think you have acted rightly. I think the electoral members do have the right to speak. Well, I have been listening to you carefully. Response from you, administration. I have explained just now. I have nothing to add, Madam Chair. Mr. To. I want to talk about paper 623 bracket 04. For this particular paper, Mr. Shek, do you have any other views? No. Well, I will give the priority to Mr. Shek because Mr. To, you have spoken for a long time already. I'm talking about 04, but it's related to 03. Well, this is a new viewpoint, Madam Chair. I don't want to make repetitions for paragraph 4 in 04 paper. I hope that you can think through this carefully. Mr. Shek said that he would seek a judicial review. Now, the administration, you should not just rush into this because you want to do it fast and then take the risk. Now, let's go back to paragraph 4. We're not talking about the beneficiaries. Now, I said earlier about minors who are HKPR and also mentally incapacitated persons. I have talked about their differences. Now, here we're talking about the trustee. Now, let's be clear about the context first. Now, we said that we are afraid of abuse. Now, we earlier suggested that the trustee should be a HKPR, and then that can resolve the problem according to some members. So you said here that, well, it's line 6 in the Chinese version. Since such an arrangement would discriminate against a certain HKPR based on the HKPR status of their parents or guardians, legal advice is that such an approach is not advisable from the human rights perspective. This is what you have written down. So in other words, the trustee may be at HKPR or non-HKPR. But then if the interest of the minor is affected, then that is not advisable from the human rights perspective. Now, for the beneficiary, well, both of them say beneficiaries and HKPR, one is a minor, the other is a mentally incapacitated person. Well, using your policy perspective, there is a difference between the two groups because the mentally incapacitated person can have his own home. Well, that has a problem with that kind of legal perspective. It exactly goes against your rationale here. So if you're trying to make a differentiation between the two groups of beneficiary from the perspective of the HKPR status of the guardians, and that is going to be very dangerous. Well, this is a new viewpoint and not a repeated remark. Administration, you have heard Mr. To's view. Do you have anything to add? No? Mr. Paul Chair. The government says that in Ms. Hong's case, This is just on CSSA, so we don't need to be worried because it is not going to affect our position here. But I want to remind the administration that in this particular case, the administration, in drawing up its policy objectives, set several things. Facilitating a family reunion, and because of the aging population in Hong Kong. And then the CFA made a judgment saying that these policies are going against the government's original policy objectives. Now, in the present case, you said that you have to grant exemption to minors under 18 years old, and your policy objective is to cool down the exuberant property market. And at the same time, you should not discriminate against HKBL, no matter whether they are above or under 18 years of age. So you are making a 180 degrees U-turn here. So you have to be very clear in your policy objective. Mr. To talked about the problem about trustees, and you are putting yourself in a risk, and you would be subject to challenges by other people because you are not making a sound justifications. You're just repeating your stance, and you are making a U-turn on your policy. And it seems that you are introducing changes after you have heard views from people, and you have not given due consideration to your policy objectives. And your latest proposal will expose yourself to the risk of being challenged by other people about your original policy intention of not making any discrimination against people who have or have not HKPR status. All right. Discrimination, originally, we divided minors into two groups. One is the having guardians or trustees who are HKPR, and the other group whose guardians and trustees who are not HKPRs. And we said we should not just target on type 2 children because that is going to create discrimination. So we would not be making differentiation within the group of minors, as suggested by Ms. Regina Yip, says CSA. And the original bill, we provided for exemption for minors and mentally incapacitated persons by way of the purchase of property by a guardian or trustee. They do need a person to do that on their behalf, and hence we allowed for trustees and guardians to do property transactions. For other people in Hong Kong, they do have to enter into agreements themselves. So the difference lies here. We've heard members' views, so we will carefully consider your views. Well, please take these views back to the administration. You don't come from a legal background, and I think these are the lawyers, and they raise these legal points of view. Please consider them. Try to strike a balance. Mr. Porter, I understand what the Deputy Secretary said. I want you to focus on discussing about the line you drew up earlier, i.e. we should not be making discrimination between people who are below or above 18 years of age. But no, you are making a turn here. You said that you can discriminate against people under minors, people who are minors. So all kinds of lines drawn have pros and cons. So please consider all these points carefully, or else you will be putting yourself at risk, Mr. Shek. I am just asking for the records of discussions on why originally people or minors under age 18 were given the exemption from BSD. Please give us the papers and the records. we have just one official making different stances at different periods. So I've just read a book, and I want to share with you this. If a government can change its stance all the time or making U-turns after listening to people's views, and it's going to be dangerous, you should have your own positions. I want to quote from Thomas Jefferson. He is a constitution expert in the United States, and he is a politician, and he is a president of the U.S. And he said, ignorance is preferable to error, and he is less remote from the truth who believes in nothing, and then he who believes it is wrong. Well, if you know that at the outset it is wrong, and then you proceed irrespectively for a government like that, you bring shame on us. Any response from you, Deputy Secretary? Well, Mr. James To, well, I'm going to ask another question. Madam Chair, I want to ask our legal advisor, the voting order, CSA, is that right? Because that's going to affect whether I would submit a CSA. Well, I will talk about the CSAs as a whole later, and the legal advisor will also make certain reminders. What are you going to talk about later on? Because there are certain issues that have to be tackled, and that has to do with members' CSA, and I will ask the legal advisor to talk about the arrangement, who to come before who, right? Okay. Well, thank you, members, for your cooperation. We have discussed all the papers presented by the administration have done with the clause by clause scrutiny, and on the December the 25th, we have received CSAs from a number of members, and on behalf of the committee, I would speak on behalf or tabling the CSAs. And the government has accepted the Regina's CSA, and that is going to conflict with the CSA tabled by Mr. Kenneth Leung, and I have already talked to Mr. Kenneth Leung, and he said that he will give it further thoughts. He still has the right to submit a CSA. Now, because the content of the CSA varies from each other, and we have to accord various priorities to these CSAs. Legal advisor, can you talk about the priority here?
Give the floor to the legal advisor first. I'm going to ask a question. I can let you be the first member to ask the question. Let me ask the question. Then perhaps you may want to make some changes. The legal advisor can also take that into account. Yes, please go ahead. Let me ask this question. Madam Chair, as you know that I'm most concerned about 63A, capital A. That is the effective rate. It will become negative vetting. Now, my question is, if I am going to move a CSA to substitute 63A so that it is positive vetting instead of negative vetting. So I want to know about the sequence. I want to know whether we are going to vote on the government's CSA first. If it is to be included, then that's it. If it is not, then I still get the one about positive vetting. Or is it the case that whenever I put in my CSA, mine will be put to the vote first? Legal advisor, please look at the points we're supposed to deal with first, and then you can answer the question of Mr. James To. I think you are aware of his point. He raised it last time, right? Yes, let me answer Mr. James To's question in the first place. I think it isn't quite what he has thought. First of all, for 63A as it stands, there is going to be a government CSA. In other words, there will be 2 amendments. Mr. James Cho's amendment is to replace the clause involved. So who will come first? I think it will be Mr. James Cho's amendment first. I have reason to believe that Mr. James Cho's amendment will come first, in accordance with the prevailing principles. But of course, I'm talking about the principles, and that we need the consent of the President to allow Mr. James Cho to move the motion, and then Division 3 will be the division to deal with the actual sequence of the CSAs. Now, the Bills Committee has accepted various amendments from different members. There are disparities among the various CSAs, so there's a need for us to decide on the sequence of the CSAs. We need to make a decision. This is because they are making amendments to more or less the same place in the bill. Now, if we are to consider a sequence, first of all, we can consider when the amendments have been proposed, and that can be a decisive factor. But of course, as I have said, first of all, we require the agreement of the President for the movement of the moving of the CSA, and then our colleagues will also apply the principles to make a final decision. So legal advisor is saying that either we make a decision ourselves, or we can just adhere to the sequence of the submission of the CSAs. I will be the one moving the amendments. But first of all, let's look at the sequence. James Cho, I don't quite understand. Now, if it is to be an amendment from the Bills Committee, then the chair will move it. If it is not, then I will move it myself, right? And similarly, similar arrangements for CSAs from other members. Now, do we need to decide on the sequence of the CSAs to be moved by the chair? Members are going to put in the notice differently, separately. Legal advisor, I think it would be the case of one member, namely the chair, moving amendments on behalf of the Bills Committee. But then there will be more than one CSA, and then the CSA can be moved. I mean, you can give notice at different timings. And it is impossible for me to turn the various CSAs from different members into a single one, because there are conflicts among them. Madam Chair, it so happened that I was absent from that meeting. Chair, how many CSAs will be moved by you? Abraham Shanks, Andrew Leung, Kenneth Leung, and Tommy Jones. So they're no longer CSAs belonging to individual members. They will all be moved by you, Madam Chair. So there will be 4 groups. Now the legal advisor's concern is that the sequence will have a bearing on the approval of the CSAs. For the sunset clause, Andrew Leung would like to have it expired in 2015, and for Tommy Zheng, 2014. So we have to make a decision as to which one will come first. When the first one has been negatived, then the second one can be moved, but not vice versa, because the amendment The amendments being sought are exclusive of one another. Madam Chair, in the 10 minutes or so that we have got now, we have to decide who should come first. I don't think it is up to the chair to make the decision. I think it's better for the legal advisor to point out whether there are conflicts among all the CSAs. Just two, Mr. Abraham Sheik's CSA and Mr. Tommy Cheung's amendment. And that's about companies of Hong Kong PRs. The two sets of amendments we have to decide which of them should come first, and then also the sunset clause raised by Andrew Leung and Tommy Cheung. Abraham Sheik, I fully support you, though sometimes you don't let me speak. I always allow you to speak. There are criticisms that I've been too lenient. Andrew Leung and myself would like to leave it in your hands. It shows that we have full respect for you and you enjoy high status. James too? I don't quite understand. The reason is simple. Sorry about that. For the chair's position, I don't want you to be suspected or smeared, because after all, you are a member of the Executive Council, although you are here wearing the hat of the chair of a Bills Committee of the Electoral. I think if we can have a resolution, I don't know, but then if we have a resolution, then it means that the Bills Committee should decide on the sequence. If the two members can agree among themselves, then probably the majority of the Bills Committee members would also agree with them. However, if we are to leave it in the hands of the chair, Mr. Abraham Sheik finds it agreeable, but I also agreed to the CSAs from members to be moved by the chair. I wasn't present, but Emily Lau spoke on behalf of our party. I think it's too risky to leave it entirely up to the chair. It's better if we have got Tommy Cheung's presence today. It will be too risky. Well, in fact, we haven't got a quorum at the moment. Legal advisor. Thank you, Chair. For the two groups of amendments, I think we can think along this line. We're supposed to exclude Hong Kong PR companies from the payment of BSD. I suggest that this can come first. In other words, the one from Tommy Cheung, and to be followed by Mr. Sheik, because this is more comprehensive, and then Mr. Sheik's is restricted. Yes, I agree, Madam Chair. And then I also suggest that we should look at the expiry date or the sunset clause. One to finish by 2014, the other 2015. Now the LA has got some observations here. I think I remember the last time you said that if Tommy Cheung's were to be passed, then you will find it entirely acceptable. What adjective should I use? I think for Mr. Sheik's, you want to have the stamp duty levied first and then you will be reimbursed. Now for the sunset clause, either 2015 or 2014, and the two are in conflict with each other. Madam Chair, we haven't got a quorum. For the two SSAs, one of the members is not present. It's better to consult the relevant members before we make a final decision. Yes, grateful to you for your comment. We'll come to an initial view and then we will write to the relevant members, in particular those moving the amendments. In due course, their concerns can be dealt with. Abraham, for BPA, Mr. Leung and myself are willing to leave it entirely in your hands. So I don't have any comments. Between 2014 and 2015, which one should come first? Mr. James Toh. Mr. Tommy Cheung is not present, but it doesn't matter. It's up to him to decide to be absent from the meeting. If they don't have strong views, I'm just guessing the views of the majority of members. If Mr. Cheung, for Mr. Cheung's amendment, the expiry will come earlier. If Mr. Sheik doesn't object to Mr. Cheung's, no, it's Mr. Leung that would want it to expire in 2015. If we have Mr. Cheung's first, then Mr. Leung cannot move it. That will be fine. I think for Mr. Leung, he will find it acceptable. If he says so, then other members will probably agree, so we can have 2014 first. So Tommy Cheung's first, and then Mr. Leung's amendment lastly. No. Mr. Tommy Cheung, and then Abraham Sheik, and then Tommy Cheung. It has to be raised separately. Tommy Cheung, Andrew Leung. And then to be followed by Kenneth Leung, because it's something else. And we'll just check if they've got any other views.
Madam Chair, I don't have any objection. Mr. Paul Chair, I don't want to add any more troubles. Well, if we veto down the 2015 first, and we can still consider 2014, then if we do it in the reverse way, the other CSA will not get a chance to be considered. So I have different views here. Well, if members don't have any objection, I will talk to Mr. Tommy Cheung and Mr. Andrew Leung to decide who to go first. I can speak on behalf of Mr. Andrew Leung, i.e. leaving it up to you to make the decision. Well, if members don't have any objection, then we'll do it the way discussed. Madam Chair, for these 4 sets of CSAs, all of them will be submitted by the chairman. If they can be split up to reflect the wishes of the different members at different stages of the scrutiny period, can we break items up further down? For example, for one batch of CSA, there may be different items or elements. And then different political parties have their own considerations. For example, Mr. Abraham Sheik may submit this batch of CSAs, and the political party may agree to one item and not the other in the same batch. So if we do it in one basket, it will be difficult to handle. So can I ask the chairman to break down the different items in the CSAs so as to reflect the wishes of the members towards different small items? While for CSA, which comprises several elements, they're going to be broken down certainly. If more than one clauses are involved in one CSA, they will be considered separately, one by one. Okay, so much for this discussion subject, and we have already made the decision. One more question. Well, what is the time frame? Because I'm going to submit a basket of CSAs. What is the deadline? Well, the policy address is coming up. Would we hold last sitting before the Lunar New Year? I want to know how much time I can have for moving my CSA. Initially, we want to resume the second reading debate on the 19th February sitting before the budget. If we can do that, government should submit the document to the House Committee by the 4th of February, and the House Committee should discuss it on the 7th of February. And the notice should be given in the 10th of February. So it says there's still some time. I think this is good. So just, well, in fact, 1 month. Well, in the extreme case, if I'm just going to move 1 or 2 minor CSA, then I will not call for another meeting to be held. I can move the CSA, and then the government can respond accordingly. But then, if the CSAs are going to be many, not just myself, but moved not just by myself, but Mr. Kenneth Leung, can you give us a deadline then before the Lunar New Year? And if there are many CSAs and which are complicated, I would suggest that we hold another meeting to discuss those CSAs. Now, actually, the scrutiny has been completed. I don't want to delay anymore. All right, Clark, if we have to send a document to the House Committee on the 4th of February, is there any limit on our procedures? There is no hard and fast rule. Of course, the earlier the conclusion we make, the more time will be allowed for the Secretariat and the administration to prepare the report for the Council and the House Committee. Well, there is no deadline then. Yes. All right, there is room, I believe, if members have new information to provide to the committee, then I'll circulate it. And if members are agreeable to a meeting to be held in case it is needed, then I will seek members' views. All right, you've actually raised many comments that I know. And if there are certain comments which will be submitted, then we have to discuss them. Well, let's not do it too near the deadline because the Secretariat needs time to do work. Mr. Shek, can the legal advisor tell us, because Mr. Kenneth Leung's CSA and Ms. Regina Yip's CSAs is vastly different. And Mr. Kenneth Leung mentioned about exemption for people who have to stay permanently in Hong Kong. So, but for Mr. Regina Yip's CSA is different. What is the difference between the two SAs? The only common point is 18 years of age. Legal advisor, can you explain to me the differences? Yes, the two CSAs are different in content. Mr. Kenneth Leung can still, via the Bills Committee, move his CSA. Generally speaking, if I understand it correctly, Mr. Kenneth Leung is adding on top of the government's CSA. So the government CSA should come first, and when it is passed, then Mr. Leung's CSA will not be voted or considered. So we are not trying to block his way. I've been communicating with Mr. Leung. He's still considering whether to move his CSA. Well, thank you, members, for your cooperation, and thank you, the administration, for attending so many meetings in the past, and also the help of the clerk and the legal advisor. So I'll declare the meeting of the Bills Committee adjourned now. And then if there is nothing untoward happening, then we'll resume the reading at the Council on the 19th of February. Thank you very much.